College football season may be over on the field, but it is not over in the courts. May it please the audience, I'm Rich Schoenstein. Welcome to So Sue Me, and today we're going to combine two of my great loves, college football and litigation, because there's a new lawsuit filed by Duke University against its quarterback to try to keep that individual at school. As many of you know, my team is the Ohio State Buckeyes, who fell a little bit short this year, losing a game each to the two competitors for the national championship. And congratulations to Indiana, one of the great stories ever in college football. But here's another story that has caught my interest, particularly as it impacts and shows some of the things going on in civil litigation. All right, here we go. Duke quarterback Darian Mensah has entered the transfer portal, as reported here by ESPN. And all indications have him potentially going to Miami, where he would replace Carson Beck, who just led Miami to its national championship defeat by throwing that horrible interception at the end of the game and then leaving the field without speaking to any of the opposing players. Anyway, this quarterback from Duke, Darian Mensah, is apparently intending to head to Miami to replace Beck. Now, if you don't know anything about college football, let me just catch you up to date. These players sign with particular schools and then at least once a year can enter something called the transfer portal, where they make it known that they are open to being recruited by other schools and switching schools. And very often they have a deal negotiated before they enter that portal. But, this has become a bidding war for highly valuable players like a star quarterback. Mensah was apparently earning $4 million at Duke and presumably would earn more than that. So that's what's happening in the world of college football now. You may or may not like that vis-a-vis college football, but it raises some implications in terms of commercial transactions because these relationships are governed by written contracts. And these players, even though they're extremely young, they're adults. And adults can legally enter into a written contract and are therefore expected to abide its terms. And that's why these student athletes need to be very careful understanding what they're agreeing to and how they proceed thereafter. Now, in Mensah's case, apparently this happened Friday evening right before the portal closed. He had committed to Duke. He had said he was returning to Duke. He had publicly announced it. But then at the last minute, he put in a transfer application and he announced on social media that he was leaving. Duke did not appreciate that. And here, Duke's lack of appreciation takes the form of a lawsuit filed in the General Court of Justice, Superior Court Division in the state of North Carolina in a case called Duke University v. Darian Mensah. And we have the verified complaint and application for a temporary and preliminary injunctive relief in aid of arbitration. It says right in the introduction, this case arises out of the decisions of a star quarterback in the increasingly complex world of college athletics. But at its core, this is a simple case that involves the integrity of contracts. And that's the pitch that Duke's lawyers are making in this case. This is about a contract, a written contract, an unambiguous contract, and it's relatively simple in that regard. So signed his multi-year contract in July of 2025. It ends December 31, 2026, and provides Dukes with rights, including the right to use Mensah's name, image, and likeness, and then, of course, has requirements to pay Mensah accordingly. It goes on. Contracts mean something. Mensah's actions violate numerous provisions of his contract with Duke University and disregard his premises and obligations to the university. And as Mensah agreed when he signed his contract, such breaches cause Duke irreparable harm for which there is no adequate remedy at law, and in the event of such breach, Duke is entitled to injunctive or other equitable relief. Under the terms of the contract, the parties are required to submit to arbitration all dispute including claims for breach. Duke University has done this, filing a claim for arbitration with JAMS. But if Mensah is permitted to continue his course of ignoring his contractual obligations and transfer to another school to compete in football and license his NIL rights to that school, Duke University will have no ability to protect its rights in an arbitrable. I guess this is the time to interject because this is kind of a fundamental premise of this litigation, and it comes up a lot in the world of business and in commercial contracts. The contract that Mensah signed with Duke has an arbitration provision. Disputes are supposed to go to arbitration to the tribunal called JAMS, and you would select arbitrators and have a proceeding to determine who's right. But the contract also says that Duke can seek injunctive relief in court. This is something we call an injunction in aid of arbitration. In a lot of cases, and I've done it myself many times, you can go to court before the arbitration because you need relief immediately that you're not going to be able to get in arbitration. And this is a perfect example. The relief Duke wants is to stop him from transferring schools. And if they allow him to transfer school and they go on and have this long arbitration proceeding in JAMS, even if Duke wins, they're not really going to be able to enforce their rights because he will have gone and played for another school. So Duke is saying to the court, you have to enforce this contract and enjoin him from leaving at least until the arbitrators can determine the ultimate case in JAMS. That is an injunction in aid of arbitration. Now, to get an injunction or a temporary restraining order in court, as a general matter, you need to show three things: likelihood of success on the merits, irreparable injury in the absence of preliminary relief, and a balance of equities in favor of the movant. Sometimes you also have to show that the public good is benefited by the injunction. Depends on the state and their rules. But the two things right up front, likelihood of success and irreparable injury, are fundamental to any request in court for a temporary restraining order or preliminary. Here, the likelihood of success on the merits argument is pretty straightforward. We have a written contract. It has a term that goes through the end of 2026. He is violating by leaving. Therefore, we're going to win. The thornier issue is irreparable injury. Will Duke really be harmed irreparably? I mean, forget about money. Duke has obviously committed some money to this, which in theory it can recover. It may even get a buyout from Miami. If the player transfers to the new school, there may be money incoming from that school to take care of the monetary loss. So the question is losing a star football player irreparable injury? One of the things Duke is saying apparently is that it's now so late in this portal process, we can't properly replace him with another star quarterback. He's given us notice at the last minute. This is going to devastate us for next year. Is losing football games irreparable injury? There are great questions here about what is irreparable injury that'll have to be sussed out in this case. I want to look at a little bit more of the complaint and the contract. All right, so Duke is proceeding under a North Carolina law, the Revised Uniform Arbitration Act, which expressly says that a court may enter an order for provisional remedies to protect the effectiveness of the arbitration proceeding. That's what I was just talking about, an injunction in aid of arbitration. It's a complaint, so you have the standard allegations about parties, jurisdiction, and venue. We'll pass over that. Factual background, there's some allegations in this complaint about how the NCAA got to this whole NIL framework. That is the subject of many podcasts. I'm not going to take that on, whether having this NIL thing is a good, bad, or indifferent thing. I can refer you to some really great college football podcasts if you want to hear people talk about that. But it is, in fact, what exists right now. Then they allege that Mensah and Duke entered into a contract. Remember, he transferred to Duke from another school to begin with, and they enter this contract in December 11th, 2024 that's supposed to go through the end of 2026. They have some allegations about the contract. Specifically, Mensah promised he will not make any similar commitment, whether through execution of a letter of intent or otherwise, to enroll at or compete in athletics for another collegiate institution. So he expressly promised he wouldn't go play for another school, in short. And that is fundamentally the breach of contract that's being alleged here. There are some others, but fundamentally it's going to play for another school. Also, the contract says Mensah and Duke agreed that any breach shall cause Duke irreparable harm for which there is no adequate remedy at law, and in the event of such breach, Duke shall be entitled to injunctive or other equitable relief. That kind of provision shows up in a lot of contracts so that the person on the other side, when there is a breach, can go to court and say, we shouldn't have any argument about whether there's irreparable injury because the parties agreed in the contract that breach would be irreparable injury. Now, I will tell you, courts don't always buy that. Some courts do look at that. I think most courts take it into consideration that the parties agreed a breach would constitute irreparable harm, but they take it into consideration with at least a little grain of salt, and they still review the reality of the situation to see if, in fact, there is irreparable harm. They go over the facts of his announcing his departure. They point out on Friday, January 16, sports media reports began to circulate that he was considering transferring. And they point to, I don't know that this is also relevant, but they're trying to inflame a little bit. So they point to the excessiveness of the apparent Miami proposed contract, which includes a buyout of the Duke contract, paying $10 million, country club housing, an Adidas deal, and supposedly a free ride scholarship for his sister. So they're trying to imply that there's something inappropriate about everything Miami is offering. Of course, at the same time, Duke was paying the guy $4 million. So what are we really talking about? Our deal was appropriate, but theirs is inappropriate. I think you could argue that they're both what they are. Then they go over the facts of Mensah, posting that he's forever grateful to Duke, but he's leaving. Thank you. Bye-bye. By his request to enter the transfer portal in this announcement, Mensah made clear his intent to breach the Mensah contract, repudiating a number of the promises and agreements that he made. They allege that they have commenced an arbitration proceeding, which they did. They attached that as an exhibit. They filed at 5:15 p.m. the following Monday, and they allege irreparable harm. They say once Mensah enters the transfer portal, Duke University will be unable to protect its rights under the Mensah contract or to undo any actions that Mensah or his representatives might take that violate Duke University's rights. They point again that he agreed in the contract that a breach would be irreparable harm and that they would be entitled to injunctive relief. And they say, and this is really the most important point, any relief in the arbitration would be ineffective if, prior to appointment of an arbitrator and commencement of that process, Mensah enters the transfer portal, transfers to, enrolls in, and plays football for another collegiate institution, and enters into an NI agreement with such institution. They're saying if you don't stop him now, there's almost no point in going to arbitration. They have only one claim for relief for a temporary restraining order and preliminary injunction pending arbitration. By the way, usually when you go to court on this kind of thing, you seek a temporary restraining order. That's something the judge would sign right away. And then a preliminary injunction, which is the same thing, but a court will only enter it with a little more review, an opportunity for the other side to be heard, and often an evidentiary hearing to go over the facts. I don't know yet what the court is going to do in this case, whether it would give a temporary restraining order, whether it would require a preliminary injunction hearing. That remains to be seen. Now, their claim for relief is for a temporary restraining order to bar him from entering the portal, enrolling in another school, playing football at another school, licensing his NIL to another school, taking any action that would impair Duke's rights under the contract, committing any other breaches under the contract, and they seek the same in terms of a preliminary injunction. They attach to the complaint the actual Mensah contract. If you like contracts, which I do, this one is very interesting. There is a name, image, and likeness license, and you'll see the term is from July 1st, 2025 until December 31st, 2026. Side note, I found that interesting because you play now playoff games in January, so I don't know what happens. I assume if he made the playoffs next year, maybe they would extend this, but I found that interesting that it had a calendar year cutoff. It's signed by Mensah, no parent or legal guardian signature, but the dude's a grown-up, so he can sign a contract. He doesn't need a parent. He doesn't need a legal guardian. If you're an adult, if you're over 18, you can enter into a legal contract. You can be bound by it. It doesn't matter if you haven't graduated college. It doesn't matter if you never went to college. You're an adult. You can be bound by a contract. This is basically a license agreement with a license grant of his name, image, and likeness to the school. You will see right away they deal with the area of exclusivity during the term. Student athletes shall not license, otherwise authorize, or permit the use or cause to permit or to a third party the rights. So by entering into an agreement with another school, say Miami, he would plainly be in breach of that provision. Among others, there's some specifics here regarding the use of the name, image, and likeness rights. That, too, is not a subject for this podcast, so I'm scooting past all of that. I'm scooting past a lot of the legal boilerplate and other provisions and just getting to the things that interest me in this discussion. Now, there is a limitation of liability here that says neither party shall be liable to the other for any consequential, indirect, exemplary, special, or punitive damages for any loss or actual or anticipated profits arising out of in connection with this license, regardless of whether such damage was foreseeable. And then it says, in no event will either party's total liability to the other exceed the total value of all consideration provided by Duke to student athlete under this license. So there's a cap of monetary liability that Mensah could have to Duke, which is essentially what he was paid by Duke. And presumably a school like Miami is ready to stand up and cover that to get this good quarterback in the door. That's not really going to preclude him from leaving the fact that he might be held liable for breach, the fact that he may be held liable for monetary damages. They're limited under the contract, and he can get coverage for them. And he can just plain get a better deal. So economically, it might make sense. Because of that, and in part because of that, there is a provision here that we talked about a little bit before where student athlete acknowledges that any breach would cause Duke irreparable harm, and they would be entitled to injunctive or other equitable relief, even prior to the dispute resolution process. And then there's a provision requiring ultimately that the disputes be settled by arbitration in jams in Durham County, North Carolina. All arbitration proceedings shall be closed to the public and confidential, and all records relating thereto shall be permanently sealed, except as necessary to obtain court confirmation of the arbitration award. One of the reasons parties, businesses, individuals often decide to agree to arbitration is to keep it confidential. You don't get reporters inside an arbitration proceeding like you might inside a courtroom. And so they keep those proceedings confidential. But of course, the proceedings in the North Carolina court are not confidential. They're open and they can be covered and are being covered by the courts. So that's the contract. You can see again, it's signed by the student athlete directly on his own behalf because he is an adult and he can enter an adult contract. Now, the reporting I saw late yesterday was that the judge in North Carolina denied Duke's initial request, which was to bar Mensah from being entered into the portal. The judge said, no, the university has to enter him into the portal, so presumably he goes into the portal. I don't know that that is going to block the continued effort to enjoin him from signing with a new school, playing with a new school. I imagine the judge was thinking this portal thing, he either goes in now or he doesn't go. So if I block him from the portal, I'm essentially making a final ruling on the case on day one, and I don't want to do that. So put him in the portal. Let's make the first step. I don't think that's the end of the proceedings. I assume there will be further discussion with the court. Again, I talked about before the difference between a temporary restraining order and a preliminary injunction, but presumably Duke will press its case trying to keep this player from breaching his contract and going to play for Miami. And then, of course, Miami is at some risk banking on a quarterback that could be bound by contract and prohibited for playing for Miami. And maybe Miami has to think about that. Should they be looking at some other quarterback that's out there and available, or somebody already on its roster? I think the whole thing is fascinating from a college football perspective, but it also interests me from a commercial litigation perspective. Here are my takeaways. Number one, contracts are important and can be enforced. And again, not to beat a dead horse, but if you're an adult, if you're legally an adult and you sign a written contract, you're going to be expected to comply with the terms. So if you're doing that, and if you're one of these student athletes doing that, get a lawyer to help you negotiate the contract, make sure you understand the contract, make sure you know what you're getting into. I have no idea if this quarterback had a lawyer or not when he got into this, but he should. Everybody out there that's entering a $4 million contract or even something substantially less should have legal advice. Number two, temporary restraining orders and preliminary injunctions are hard to get, particularly because you have to show irreparable injury. How is Duke going to be irreparably harmed if this quarterback violates the terms of the agreement, especially where that agreement has a cap on monetary damages? The parties agreed no damages could be more than the amount he was paid to play at Duke. So how are they irreparably harmed before that? That is an interesting argument. That's probably the most interesting legal argument to me in the case. And then third, the juxtaposition of civil litigation and arbitration. Even in cases where the parties have agreed to privately, confidentially arbitrate their disputes, they can still end up in court on an application for a preliminary injunction in aid of arbitration. Happens very often. Parties go off to court to try to get that injunction so they can maintain the status quo, keep everything as it is, and then go to arbitration and finish the determination of the dispute privately with an arbitrator. We'll keep an eye on this litigation. We'll keep an eye on college football. We're now at the off season. We're gearing up for the 2026 season. We're gearing up for a rematch with Indiana, all sorts of stuff. And we're gearing up here to talk about more civil litigation issues. Thank you so much for watching. Go ahead and subscribe. Go ahead and like the video. Give me some metrics out there, people. We'll see you soon. For now, we are adjourned.